5 seconds to go. Start. Civil Appeal numbers 1890 and 91 of 2010 is directed against the judgment dated 19th October 2007 rendered by a division bench of the High Court. Writ Appeal number 478 of 2007 and Writ Appeal number 1026 of 2007 were appeals generated by the judgment which was rendered by the learned single judge in writ petition number 4766 of 2007 dated 20th February 2007. By the same, the learned single judge allowed the writ petition filed by the writ petitioners who are the appellants before us. It was inter alia stated that their case that they were owners of certain apartments situated in a complex which consisted of 12 blocks. The total area of the layout was more than 10,000 square meters. A portion of the land was earmarked in terms of Rule 19 of the Development Control Rules, hereinafter referred to as DCR, as Open Space Regulation Area, hereinafter referred to as OSR. A gift deed was executed in favor of the Chennai Metropolitan Development Authority on 18th February 1994. However, despite the lapse of 12 years of the gift, the OSR area had not been developed into a park. The learned single judge disposed of the writ petition by directing the appellant association to maintain the open space area as a park with recreational facilities in accordance with the DCR. It was also made clear that it is always open to the respondents to take action in accordance with law if there is any violation. It was found to be the duty of the respondents to maintain such open areas as parks, and on there being a failure on their part, the association of the residents should be welcomed to do the same subject to the rules. Writ Appeal number 478 of 2007 was filed by one Shri Gopinath and others. They were persons who were living in the neighborhood. Writ Appeal number 1026 of 2007 was filed by the Commissioner of the Corporation of Chennai and the Member Secretary of the Chennai Metropolitan Development Authority, hereinafter referred to as the CMDA. It was by the judgment impugned in Civil Appeal numbers 1890 and 91 of 2010, the division bench allowed the writ appeals and set aside the judgment of the learned single judge. We notice the following findings and relief granted. When the land has been assigned in the year 1994 in favor of the CMDA by way of the gift deed, neither the CMDA nor the Corporation of Chennai have taken any step to make use of the land for the interest of public. It is clear from the report filed by the Advocate Commissioner and the photographs filed before us and the other materials available on record that in the OSR area there is a Kacha road which is said to have been laid by the corporation in the year 2003. Probably because of this Kacha road and the usage of the same, as road by all the residents in the locality. The occupants of the Vasanth apartments might have felt disturbance, which would have promoted them to make a representation to the corporation to develop a park in the said area, or in the alternative to permit them to develop and maintain a park for their recreational purpose, besides illegally constructing a compound wall separating the petrol bunk and the compound wall for about a length of 30 feet, separating the unbridged 11 feet wide open canal up to ground level, so as to close the way once and for all. At this juncture, it is to be pointed out that the Vasanth apartments is divided by a compound wall from this area, and it is also not made clear by the Vasanth Apartments Owners Association that the said land, which was gifted to the CMDA, is a part of their layout. Stop.